All right, today we're jumping into a legal case that honestly sounds more like a thriller. It's Boothe versus the Director of Patents, but I think a better name for it is the case of the 9 missing pages. Let's just kick things off with a question. Imagine this. You've just discovered something that could literally change the world. Maybe a new wonder drug. You file the patent. You think you've done everything by the book. But what if a tiny clerical error, we're talking just 9 missing pages, could make it all fall apart?
So, to really get what's going on here, we've got to rewind the clock. We're going back to the 1950s, right in the middle of this super intense competition in the pharma world. People were calling it the Great Tetracycline Race. So, the main players in our story are 2 American chemists, James Howard Boothe and John Morton II. And these guys, they invented a brand new antibiotic called tetracycline. Now you got to understand, this was a huge deal back then. Their goal wasn't just to lock down a patent in the US. No, they were thinking bigger. They wanted to secure it globally, and their first big international step was filing in the Philippines. And this is where we get to the real heart of the legal battle. See, in the world of patents, it's pretty much all about being first. It's a race, right? It's all about locking in your spot at the front of the line. Okay, so here's a quick look at the timeline. Boothe and Morton file their patent in the US on March 16, 1953. Got it? Then, just under a year later, on March 5, 1954, they file in the Philippines. Their entire strategy, everything, was riding on getting the Philippine Patent Office to honor that original US filing date. And to do that, there was a rule. You had to file within 12 months to claim what's called priority. Look at the dates. They just squeaked in. Or, well, that's what they thought. So that legal magic they were counting on? It's called a priority right. And trust me, this is a seriously powerful tool in international patent law. What it does, essentially, is let you backdate your international application to your original filing date back home. It's like a shield, right? It protects you from some other companies swooping in and filing in another country after you invented it, but before you had a chance to file there yourself. So you have to realize this isn't just about shuffling papers. A priority right is basically like getting a universal timestamp on your idea. Boom. It freezes your place at the very front of the line, not just here, but everywhere. For Boothe and Morton, this was literally everything. But there's always a but, isn't there? While their application was just sitting in the patent office, a huge problem was lurking, and they had no idea. A problem that would become infamous for, you guessed it, 9 missing pages. And get this, they didn't find out about this problem for 5 years. Can you believe that? 5 years of complete silence after they filed, all the while thinking their spot in line was totally safe. Just, wow. Imagine how frustrating that would be. So then, boom, 1959, the bomb finally drops. A patent examiner contacts them and says, hey, your application, it's incomplete. And this quote from the examiner just lays it all out plain as day. Their whole scientific description just stops, dead. Right in the middle of a sentence, it says, the refractive indices of this crystalline phase were found. Found what? The absolute core of their invention's description was just gone. Okay, so what do you do in that situation? Well, in 1962, Boothe and Morton submit the missing 9 pages, probably thinking, okay, simple fix, no big deal. But nope. The chief patent examiner rejects them flat out. He calls it new matter and basically says you can't just add important info to an application after you've already filed. He even states that the super strict deadline for claiming priority rights cannot be extended directly or indirectly. And that's it. His decision is final. Their only move now is to appeal to an even higher authority. So the case keeps climbing the ladder, all the way to the very top. We're talking about the Director of Patents. This person's ruling, that was going to be the final word, the end of the line. And what the director decides is, well, it's fascinating. It's totally split down the middle. So first, the good news. He actually disagrees with the first examiner. He says, sure, let's admit those 9 missing pages. They aren't new matter. Great. Their application can finally be examined. But then, the bad news. And it is a gut punch. He denies their priority rights. And he does it by just changing their filing date. Now, you're probably thinking, wait a minute, how can he even do that? The whole appeal was just about admitting the pages, not the filing date. Well, turns out the law gave him that exact power. There's this little thing called Rule 262B, and it says the director can rule on any reason for rejection he finds, even if it wasn't what the appeal was about. He clearly saw a much bigger problem here, and he decided to deal with it. And this right here, is what it all boiled down to. The director officially moved their filing date from March 5th all the way to April 14th, 1954. So why that exact date? Why April 14th? Well, because that was the day they finally submitted a complete, certified copy of their U.S. application. In the director's eyes, that was the first moment their application was actually whole. So you gotta ask, why was the director so incredibly strict about this? I mean, why did this one little date change matter so much? Well, as it often does, it all comes down to the letter of the law.
It all hinged on one brutally clear rule, Rule 47. And it says an application's official filing date isn't when you first submit it. It's the date on which the complete application is received. Not almost complete, not good enough, 100% complete. Those missing pages, they weren't just some minor informality you could brush aside. No, they were a major substantive defect.
And this right here is the final nail in the coffin. Let's do the math. Their U.S. filing was March 16th, 1953. That means the 12-month deadline for those all-important priority rights was March 16th, 1954. By changing their filing date to April 14th, 1954, the director officially shoved their complete application outside of that critical one-year window. They missed the deadline by less than a month. Ouch. But come on, why are the rules so unforgiving? It seems so harsh. Well, the court actually laid out why. A patent filing, it has to do 3 really important jobs. First, it has to tell the public exactly what the invention is. Second, it has to give the courts a crystal clear document to work with if there's ever a dispute. And third, it has to be a clear signpost for competitors, telling them exactly what they need to steer clear of. An incomplete application, it fails on all 3 counts, miserably. And really, this one quote from the final decision just says it all, doesn't it? The whole entire system of patents is built on one foundation, a full, definite, and specific description. If you don't have that, the patent itself is basically invalid. It's not just some fussy rule. It is the absolute bedrock of the entire system. Which really just leaves us with one final thought to chew on. Think about it. Boothe and Morton lost their claim and maybe their whole patent not because their science was bad and not because a competitor beat them to it. Nope. They lost it because of an incomplete sentence on page 9. It just makes you wonder, doesn't it? In this high-stakes world where amazing innovation smacks right into the law, are the small details ever really small?